Some of the content in this video may be similar to earlier ones, but new additions are regularly made as we study more and more cases now in courts. So watch the full video to get its full benefit. There is court, opposite party and opponent advocate all against you since you are accused for check bounce. There has to be well-reasoned response if you want to come out of this. Legal experts who do not contest actual court cases at trial stage offer simple solutions with to judge Supreme Court judgments which are obiter dicta judgments and which as per Article 141 of Constitution of India are not applicable to any other cases. The check law is not child play that the accused can win by one argument or one cross questions or even one judgment. Still, there are always limitations in written words, so most of the complaints have some or other legal mistakes. You have to carefully study such mistakes and have to create your offense based on specific legal provisions and not just arguments. Offense is best defense. Now presently you are taking defense and in the process admit many facts which the complainant had omitted to state in the pleadings, and so it becomes easier for the accused to get convicted. While in offense the complainant who never expected it so gets confused and makes mistakes, and so it becomes easier for the accused to win. In-depth knowledge of various legal provisions is essential to create a proper offense. You have to also understand the correlation between general procedural laws and special laws like check bounce. In check law, various provisos of Section 138 are not legally complied by the complainant. For example, it is essential to send notice of check bounce. Most of the accused take defense that notice was not received. In the process, they have admitted the existence of and sending of notice. So, as per General Clauses Act, it is legally presumed that notice was legally sent even if the accused may have not received. The plea the even notice was not legally sent can be taken. It will differ from case to case, but effective remedy to win the case. Please send us all the documents by email and our team will prepare proper legal response. One important point which the accused should take up in the case that no legal notice was sent. We have dealt with this issue earlier also, but now adding further legal details that how accused can benefit and even win the case. Court will repeatedly ask about the check. Keep quiet. Never reply. More you will try to explain, more you will be trapped in your own explanation. Always raise the legal issue that no legal notice was sent. Go on repeating the no legal notice was sent, there are no legal documents, no evidence, hence complaint is not legal. Court will always ask how. You are not bound to reply orally. There will be temptation, avoid it. Instead reply that you will legally present your position as per procedures of law. Even your reply under Section 313, you should repeat the same or request for replies to be given in writing. If you reply orally, you will be trapped and with your own replies will get convicted. So remember, you are not bound to reply orally under any law. You cannot be compelled to criminate yourself under any law or procedure as per Article 20 of Constitution of India. Please tell the court politely but firmly that trial is to be conducted as per mandate of law and procedures under Constitution of India. The oral trial will be great injustice to the accused. Now coming to the notice issue, the legal notice may have been sent and received or not received by the accused. But its evidence in the complaint must be legal. We have not seen a simple complaint anywhere in India where there is legal evidence for notice sent to the accused. The three-bench judgment in Herman Electronics case, the Supreme Court has defined that giving of notice and receipt of notice are two distinct matters. Even the Section 27 of General Clauses Act about the notice, which is mostly used against accused, specifically says that the fact of receipt of notice can always be rebutted. The three-judge Virendra Pratap Singh judgment of Supreme Court mandates that only check bounce is no offence unless all the proviso of Section 138 are complied. And in another three-bench judgment in BIRG case, the Supreme Court has mandated that no evidence can be given beyond pleadings in any case. Why the complainant cannot go beyond pleadings of the complaint, but as accused you have all the freedom. Create mystery by your offence, which is power. It will paralyzes the thinking of opponent and his or her advocate. So altogether the accused can plead that there was no legal notice was sent and hence the complaint is not maintainable. Request the court to pass a written order in this matter. You will have opportunities to go in revision if the order is against you. It is much simpler and better solution than going in appeal after final decision of the case. The world-famous author of Fox Mindset has revealed about most important mindset how to win. A fox escapes most powerful enemies like lion as well as human hunters. Fox does not attack directly. It silently observes all the moves and at appropriate moments strikes and win. Another most important weapon in the hands of the accused in any case is cross-examination by leading questions. Only 1 in a million knows the proper importance and effect of leading questions. Most of the legal experts suggest direct questions which proves the complaint and goes against the accused. The accused should always have weapons of offense in reserve and to be used if nothing else works. One such most powerful offense strategy is the method of proving the evidence of the complaint. In all cases, the evidence of complaint is proved by leading questions, which is not legal and hence there is no legal evidence for the complaint. Supreme Court in most important reference judgment of Workey Joseph, in which the murder convict was acquitted because the prosecution evidence was given by leading questions. This judgment is being followed since last more than 30 years by all courts in India. What was in Workey Joseph judgment? The evidence was given by prosecution by leading questions to its witness, so trial court convicted the accused for murder. Supreme Court said the prosecution evidence by leading questions is no legal evidence and hence the accused was acquitted. When a murder convict can be acquitted by wrong method of taking evidence, the check bounce is a very small law and so the accused can benefit. Please tell us from which place you are watching this video and what is the current status of your court case if any. Please send email in English only. If you are facing any check bounce case, then our team will study all the documents and will suggest actionable steps in the case. There are many contradictions in complaint and also loose links in law, so it is easy to win any case. Accused can come out from open door but due to pursuit for shortcuts wants to come out of the wall which looks near and in the process gets convicted. This is the history of majority of cases in trial court for check bounce accused. In this channel we give legal knowledge which can be actually used and not for publicity hype or for clickbait tricks. So please subscribe and also send to your friends who may have its utility.